Important things to know about probate. Legal, by Melissa Sloan.
Probate is often one of those things in life that many people don't experience until a close loved one passes away and they gain their first exposure to a previously foreign world. Here we further explore probate and answer the most common questions that we are often asked.
Is probate necessary and what does it mean?
In Victoria, if you die with assets of more than $50,000 in your own individual name, your executor is required to obtain a grant of probate with the Supreme Court of Victoria. Your executor must submit to the court an affidavit and an inventory of assets and liabilities as at the date of your death, together with other documents, including your original will and a certified copy of your death certificate. Once the court has reviewed these documents and is satisfied with the information provided, it will issue a grant of representation, a document confirming that the will is valid. This formally allows the executor to administer your estate and deal with the assets of your estate.
What if the court aren't happy with the documents submitted?
Sometimes the court may issue a requisition for more information from the executor. This can occur in instances where the deceased has a dementia or Alzheimer's diagnosis or other cognitive condition listed on their death certificate, which stipulates such medical condition predates the date that the deceased put their will into place. The court in these instances is seeking evidence from appropriate medical professionals known to the deceased at the time they put their will in place, that the deceased had legal capacity to put their will in place, that they had a general understanding of their assets, understood the people who could reasonably expect to be included, and understood the implications of putting their will in place. Other instances where the court may issue a requisition include where a handmade will was written in someone else's writing and signed by the deceased, and where there is interference with the original will, for example, staples removed. The court have strict standards in accordance with what must be submitted and the proper execution of these documents. And if they are not satisfied with the forms that have been submitted or the information contained in the affidavits, they may issue requisitions in respect to these. Navigating court requisitions can sometimes be challenging, so it is important to obtain the appropriate legal advice on how to satisfy the court's requirements.
Is probate a long process?
One of the first things that an executor is required to do is advertise their intention to apply for a grant of probate on the Supreme Court Red Crest website, providing 14 days' notice. Upon the expiration of this notice, the executor may lodge the applicable probate documents with the court. The court will then assess the probate documents with the processing time depending on the court's workload at the time. But a grant of representation is usually granted within 2 to 4 weeks of lodgement with the court. The Administration and Probate Act 1958 stipulates that an executor should not distribute the assets to a beneficiary for a period of 6 months from the date of the grant of probate, in case there are any family provision claims. Should the executor elect to distribute the assets of the deceased estate prior to this expiration period, and a claim is brought against the estate and is successful, the executor will be personally liable for the claim. Once the 6-month period ends, the executor may distribute the assets of the estate to the beneficiaries in accordance with the provision of the deceased's will. Full administration of the deceased estate usually takes place within 6 to 8 months. However, this distribution period can be longer, particularly where properties need to be sold or the deceased's estate is a complex estate.
Can I search a probate?
In Victoria, once the court has granted a grant of representation to the executor, the probate documents submitted to the court become public documents and anyone may search them. It is important to note that these documents will only provide details of the amount of the deceased's individual assets at the time of their death and will not disclose the value of any joint assets that the deceased held or assets held in trust. Probate can be a time-consuming process in which your executor is required to invest considerable time undertaking a number of administrative duties to ensure that they adhere to the court's requirements and satisfy the fiduciary duty that is placed upon them. Equipped with the correct legal advice, they will familiarise themselves with the role of executor and the expectations placed on them, so that they can administer and distribute your estate in accordance with your wishes contained in your will.
Melissa Sloan is an estate planning and probate lawyer at Madison Sloan Lawyers in Park Orchards. Find them at madisonsloanlawyers.com.au. All advice is of a general nature only. Seek bespoke advice for your own circumstances. This story was read by Rebecca Rose.
Sandy Miller.